Hi, everyone. So today we are going to be talking about the top three things you need to know before you file your VAWA application. This is so important that as you're going through the VAWA process, thinking about VAWA, thinking about what you need and all those things that you know exactly what to expect because this is a long process, okay? There are things you need to know before you even file to make sure that you are setting yourself up for success. So, we're going to be talking about those three things today. I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. If you're joining me and you have questions, go ahead and put them in the comments. I will be responding to those. If you are watching this on a replay and you have questions, put them in the comments. I do respond to your questions because, of course, the US immigration process is so complex and can be very nerve wracking. So I want to make sure that you have a space to ask questions and get up to date immigration information. So the first thing that you need to think about is if you meet the requirements for VAWA. Okay. If you meet the requirements for VAWA, have you experienced battery or extreme cruelty in your relationship? Okay. Battery is basically physical violence. Have you experienced physical violence in your relationship? So, if you have experienced physical violence and you have been married to a US citizen, and during that marriage, your US citizen spouse abused you physically, then you would qualify for VAWA, right? Now, that is a simple uh, requirement, right? You know what physical abuse looks like. Everyone knows that. But what about extreme cruelty? Because it's one of two things. It's either you had the battery or extreme cruelty. And this is where people really get hung up because they're not sure what's the definition of extreme cruelty. Is it just that we had arguments, right, that other couples have? Does it have to be more than that? And typically it has to be more than that. But it's also more than that based on your particular situation, right? Based on your particular relationship. In some situations, arguments may seem like if you break it down, then you're just like, oh, we argue once in a while. That may seem not to reach the level of extreme cruelty. However, when you actually break it down to what were those arguments about? What were the words that were said in those arguments? What were the after effects of those arguments, right? That's where you start really crafting that extreme cruelty part of things. So when people come to me and they say, well, it's just, sometimes he yells. Okay, what does he yell about? Sometimes she doesn't come home. Okay, there has to be something more. So we have to, as part of my job, is to ask follow-up questions to get more information, to basically assess whether I believe it reaches a level of extreme cruelty, because that's the level USCIS is going to be looking for. Okay, it's not just simple arguments. All right. It's not just arguments about who's doing the dishes, right? It's not just those things. It's more than that. So you want to make sure that as you're thinking about your particular situation, that you are not just thinking that, just because you're married to a US citizen and you heard an argument that is enough. There's more to it. And you want to work with a lawyer or a psychologist to kind of get more information on and explore the different things that happened in that relationship. Because you, as you're thinking about the abuse that you have been through, you may not see certain things as abuse. Okay, there's certain things that may have happened in your relationship that is just normal to you because it's happened since the day you met your spouse, and for you it's normal. However, It's not just about you, right? Objectively, if someone else outside of your relationship that has not been with your partner for that long sees that behavior, what would they think of it? Okay. So remember, USCIS officers are not in your home. They are now part of your day to day lives. They are looking at what you're giving them, and they are looking at it from a lens of, does this reach extreme cruelty? Is this so egregious that we're going to see this as extreme cruelty? Approve this person's VAWA, get them on the path of of a green card, then citizenship. Is this enough? And that's what you want to always think about, is how would someone else perceive this? And make sure that when you are speaking with a lawyer, when you are doing a psychological evaluation, that you are talking about every single thing, right? As much as you can, keeping in mind that this is going to be the most difficult part of your whole process, is talking about this, right? Talking about the abuse that you've been through. I've had people, they do their psychological evaluation, and we have to follow up with them. The psychologist has to follow up with them to make sure they are okay, because it is traumatic, right? Having to talk about the abuse, relive the whole thing, is going to be traumatic. So just be prepared that, you may not want to talk about it, but if you want to qualify for VAWA, if you want to get yourself on a path to a green card without your US citizen spouse's involvement, you have to talk about it. Okay? You have to make it clear to USCIS that this is not normal, right? It's not just normal everyday couple arguments where there's no abuse. This is something that is way beyond that. So that's one thing I wanted to cover, is you have to prove either physical abuse, battery, or extreme cruelty. And I wanted to use that specific language because that is what USCIS is going to be looking for. And that's the language they want you to prove, right? That's what the law says, extreme cruelty, not just arguments, okay? So we want to make sure that we're using that, and that is the bar we're trying to meet at all times. All right. So that's the first thing you need to know. Hi, Mary. Welcome. Glad you got to watch live. Welcome. If you are joining me live, feel free to say hi, ask me questions about this or any other immigration matter. I'm just going to go over these 3 things, and then I'll get right to your questions. Okay. The next thing you need to know is that you still have to prove the relationship. Okay? You have to prove that your marriage is real. You have to prove that you two lived together. Because if you cannot prove that you lived together, if you cannot prove that you entered the marriage in good faith, USCIS is going to deny your VAWA. Okay, so VAWA is not just the abuse. The abuse is the thing that gets you into the conversation of VAWA. But if you never lived with your spouse, even for a day, right? If that never happened, you cannot file a VAWA application. If you cannot prove that your relationship was real, you will not be able to get this approved. So it's really important that as you're going through and thinking about filing for VAWA or getting out of the relationship, that you are saving things from the relationship. Because I know people that have destroyed pictures, threw them away because they just don't want any reminders of their ex, right? They don't want any of that in their new path forward. However, those things matter to USCIS, okay? Those things matter. So you want to, if you have to give it to somebody, right? If you have to give it to someone to hold for you, where it's not in your space. You don't have to see it every day, but you're able to get to it when you are ready to file your VAWA application so that you have that documentation of your good faith marriage. All right. So you want to make sure that you're holding on to documents showing that you live together. If you had a joint bank account, if you had a lease together, just whatever you can get to show that relationship you want to keep. Okay. Do not get rid of things that could potentially be helpful in your VAWA case. So before you even file, think about your life together. Think about what documents do you have? Text messages. Do not delete those. Facebook messages, WhatsApp messages, all those things, do not delete them. If they sent you voice notes threatening your life, don't delete it. Send it to a friend. Save it to the cloud. Something where you can still get access to it. Because guess what we'll do with those voice notes? We download it, we get it transcribed, and we send it to USCIS so that they can see this is the level of abuse. This is the level of physical abuse, verbal, psychological, financial. There's so many types of abuse, and you want to document it. You want to document that you live together. So you want to save as much of your documentation as possible and figure out a way to not have it in your space if that's going to be a trigger for you. Okay, maybe open a Google Docs, completely different email, Google Docs, upload everything there, and just know that it's not in your everyday Google Docs pictures and all of those things. Okay, so those are things you can do on the front end to make sure that you do not get to a point where USCIS is asking you for proof of your relationship and you're like, well, I don't have any because I threw everything away and I'm not able to get additional copies. Okay, so make sure that you're saving those things because you have to prove the marriage is real and that you two lived together. All right. The last thing I wanted to cover is how a divorce can affect the process. All right. So if you file for divorce and your divorce becomes final before you get around to filing your VAWA application, just know you have to file your VAWA application within 2 years. Okay. You cannot file it more than 2 years after that divorce becomes final. So again, this is important because sometimes people don't even think about VAWA as an option. Okay, they don't even think about it. But if that becomes an option, you want to also know that you can file even if you're divorced, as long as it's still within 2 years of that divorce. If it's past 2 years, there may be a way to, ask USCIS to still process the application, but it's very difficult to get those approved. So if you're within that 2 years, you can still apply for VAWA. The divorce will not stop you from applying for VAWA if you file within those 2 years. If your VAWA application is already pending and you get a divorce, it's not going to affect your application. Okay, it's really important that you know that. If you get a divorce while your VAWA application is pending, it will not affect your application. Now, if you get an annulment, right? If you get an annulment while your VAWA application is pending, then that's a problem, right? That can be a problem because an annulment basically says this marriage never happened, right? A divorce says the marriage happened, but we ended it. An annulment says, well, when the marriage happened, it shouldn't have happened in the first place. So let's just pretend as if it never happened. Right? That's what an annulment does. So you want to make sure that if you are going to file for divorce, that you are filing for divorce. Okay, not an annulment. Because I've had previously a client's ex try to do that to her by filing an annulment, even though they didn't meet the requirements for an annulment, right? Because there was no fraud, there was nothing about the marriage that wasn't legal or valid. So the marriage was valid, and he was just trying to stick it to her, and file an annulment. So it's really important that you do not fall into that trap, and pay attention to what your ex is filing as well, because if they file an annulment, you want to fight that, right? You want to make sure that that is not the basis that the marriage ended, that it is a divorce. Okay. All right. So those are the three things that I wanted to cover. You have to prove battery, physical abuse, or extreme cruelty, which can be other types of abuse. For example, psychological, verbal, financial, sexual, all everything else other than physical violence is under extreme cruelty, and you need to make sure that it rises to the level of extreme cruelty. It is not just a one-off argument. What about that one-off argument made it extremely cruel? All right, so you want to really think about that. You want to make sure that you have documentation of good faith marriage and of you two living together. If you do not want those documentation in your space, create a separate Google Docs, upload it there, get it out of your day-to-day life, but do not destroy it, because you want access to that when you are filing your application, because you still have to prove that your marriage was real and that you lived together. If you get a divorce, that is fine. But if you haven't filed your VAWA application yet, make sure that you are filing the VAWA application within 2 years of that divorce, or you will be out of the VAWA process. Okay. If you already have your VAWA process pending and you file for divorce, just make sure you are filing for divorce and not an annulment, and that will not affect your VAWA application, because you are allowed to leave your abuser. Okay, you are allowed to leave your abuser even if your VAWA application is pending. Just want to make that clear. All right, so if you have any questions, please put them in the comments. I do see some questions that I will be responding to shortly. All right. If you are getting value out of this video so far, please do me a favor and hit the like button, just so I know that you are enjoying this program. All right, so let's start. So the first questions I see are from Instagram, so I'm going to cover those first. I'm in the US illegally. How can I get my green card? Oh, that's a loaded question, right? Because it needs a lot more information in order to actually answer that question. Because when you say illegally, it can mean that you came in with a visa, but you overstayed your visa, so now you're undocumented. If you saying that you came through the border, some people, when they come through the border, they're given parole, and some people are not. All right. And then some people are not, have no interaction with US immigration at all when they come through the border. So it really depends on what you mean by illegal. I would suggest scheduling a strategy session, just so I can get more information about you and your particular situation. But generally, marriage to a U.S. citizen, depending on how long you've been in the U.S. If you have genuine fear of going back to your home country because of persecution that you have suffered, or you fear that you will suffer, asylum may be an option. If you have been a victim of a crime in the U.S., there are certain crimes that if you have been a victim of it, you may be able to apply for a U visa. If you have been a victim of labor or human trafficking or sex trafficking, you can apply for a T visa. There are requirements for those as well. I will be working on a T visa video for you all. It's just going to, it's a lot of information. So I want to figure out the best way to give you that information. It may be a multi-part series on that, but that is something that could work for someone that is in the US without authorization. Okay. But again, it really just depends on your particular situation and what would work for you. Because if you do not have a US citizen spouse or parent, or permanent resident spouse or parent, your options become very limited, because now an adjustment of status or consular processing is not going to be the way to get to your green card, because you need one of those in order to apply for a waiver if you entered without authorization. So, but if you entered with a visa and you have a child that's 21 and you didn't have any misrepresentation in the past, then your child can file for you and you can get a green card that way. So, like I said, it really depends a lot on your particular situation. So, feel free to schedule a strategy session with me. You can do that by going to my website, lilylegal.com, and you can see my calendar and pick a date and time that works best for you. Okay. The next thing is filing VAWA should happen after filing an I-130, or it doesn't matter? Well, it doesn't matter if you meet the requirements of VAWA and if you meet the requirements of an I-130. So your spouse, if they are abusing you and they still want to file an I-130 for you, you can still move forward with that process. Again, the I-130 process requires you to show that your marriage is real and that you two are living together, building a life together. Just because you meet the requirements of an I-130, that you're living together, building a life together, and you enter the marriage in good faith, does not mean you are not also abused, right? So one doesn't take away from the other. So you can have an I-130 pending and file a VAWA application, or the other way around. Something that happens is that people may end up filing the VAWA application after they already filed the I-130 and the green card application. But before the green card interview or the I-130 interview, there's a big blow up, and the abuse just gets worse, and they want out. They do not want to get the green card through their spouse anymore, because it's now become a form of abuse, which usually happens in those situations. And in those situations, you can file the VAWA application and have the green card application moved under the VAWA application. But it's a whole process that you have to go through. And remember, the VAWA application process is confidential. The VAWA application process is confidential. You can put a safe mailing address. So most of my clients, I'm their safe mailing address. They are not getting any mail to their home. And this is for my clients that are divorced. I don't care. I do not want you to be in a situation where you trying to get your status through VAWA becomes something that triggers the abuser to now further abuse you. So VAWA applications are confidential. You can designate a safe mailing address and make sure that nothing is coming to your home. All right. I even ask my clients, how do they want communication, right? Is a phone call okay? Is a text okay? Is email okay? I have a client portal that they can log into as well. So we really take that, confidential part very seriously. And USCIS has to take it seriously as well, because the law says they have to. And if they don't, you can sue them. But again, the point is that they should not violate that, because that can lead to people getting seriously hurt. Okay. Does filing VAWA affect or hurt the US spouse in any way? Again, VAWA applications are confidential. USCIS cannot share that information with anyone. Okay. So there's no way for that to affect your US citizen spouse, because In order for it to affect them, someone outside of USCIS has to know that they are the subject of a VAWA application. And that means that USCIS broke that confidentiality at some point. Okay. So that is not something that happens. Is it possible that, you know, you, the petitioner, may talk about the abuse that you have suffered and their employer may hear about it and it affect their employment? Yes, maybe, but not through the VAWA application, right? It may be something outside of that, but the VAWA application itself, no. It does not lead to affect any negative effect or hurt to the U.S. citizen or permanent resident spouse. How long does it take to get your green card after approved for asylum? So after you're approved for asylum, you have to apply for a green card, right? It doesn't automatically come. You have to actually apply for it. But once you apply for it, it can take anywhere from a year to 3 years. USCIS is trying to reduce their processing time on those, but that's what we're seeing right now as far as how long it's taken. Can I file for VAWA if I have a misrepresentation? Yes. VAWA is one of those applications where you can, if your VAWA is approved, you can apply for a green card even if you have a misrepresentation and need a waiver. You can be the qualifying person for the waiver. So the VAWA application itself does not care if you had misrepresentation. Unless that misrepresentation is, let's say, for example, you put on your visa application that you were married to someone else when you weren't actually married to that person. You want to show on your VAWA application that there was no previous marriage or they're going to want a divorce, right? But if it's just, you know, any other type of misrepresentation that does not affect the fact that your marriage is valid, right? Any other type of misrepresentation does not affect the VAWA itself. You can still be approved for a VAWA, which gets you deferred action, gets you a work permit and all of that. But the green card application requires you to get a waiver for that misrepresentation. So you want to make sure that you have positive factors for the waiver. And the waiver is going to be based on you suffering extreme hardship if you were to be forced to leave the US. So you want to make sure that that is being documented. So yes, you can get the VAWA even if you have a misrepresentation. The green card application is a different thing because the green card application, you're going to need a waiver, but the hardship is going to be based on you, not a spouse or a parent. Okay. So hope that answers your question. All right. Next question is from Mary. I filed for U visa in 2018 and in December 23, I got a letter from USCIS saying they don't have visa available for that fiscal year. So what do I do or what should I expect? So you do nothing. So you just wait for a visa to become available. That's a good thing because that means that they are most likely going to approve your U visa. They're just waiting for a visa to become available before they can. So they may have given you deferred action so that you're able to get your work permit and all of that under the U visa while you wait for a visa to become available. Right now, it's taking about 14 to 15 years for a visa to become available from the time you file. So just keep that in mind. Expect to wait several years for that visa to become available, but it's a good sign that your U visa is going to be approved. That's what that means. Okay. It's a good sign that your U visa is going to be approved. It's just not, there's no visa they can give you yet. Okay, they're just waiting for a visa to be available and then they can give you one. But until then, you just have to wait. You can work, and you should have your deferred action so you can get your work permit and renew those as needed until that visa becomes available. All right. And Sue is asking, I have a VAWA application pending for my 9-year-old child, but his father is a US citizen. Can he file for his son? And what forms should he use? And does he have to live with him to do so? Okay, so he can file, the father can file for the child. Typically, there has to be some form of custody arrangement, giving him legal custody of the child. The child does not have to live with the father for the father to file. It just depends on the particular situation, but a US citizen is allowed to file for their children. You know, that's the bottom line. A US citizen is allowed to file for their children. They would depend on how the child, if the child is in the US and came to the US with a visa or with a specific type of parole, the father can file an I-130 and an I-485 for the child. But if the child is not in the US or entered without a visa or parole, then they have to start with an I-130, wait for that to be approved. The child will have to leave the US to get the green card um, by going to an interview at the embassy. Okay, so that's the difference here. With a VAWA application, if the child entered without authorization, they can get their green card in the US without having to leave. But if it's through the father and they entered without authorization, they may need to leave the US to complete that process. But because they're 9 years old, and if they've only entered the US once, they most likely will not have unlawful presence, which will mean they would not most likely need a waiver. Okay. All right. Next question. God's favored. If you're married to a US citizen, file for an I-130 and I-485 since October 2021, but there's no progress in your case. Should you be concerned? Only EAD received. Husband is currently on house arrest. 2021, married to a US citizen. I would say at this, okay, he keeps telling me he can't give full details on what exactly the case is about because it's still ongoing. I'm not sure what to do. Okay. So if the, let me, if the person on house arrest, if the husband is the person applying for a green card, right? If the husband is not the US citizen, whatever that crime is the reason that your case is still pending, right? USCIS is not going to give a green card if there's a case open, okay? But if that's the US, if the husband is the US citizen, typically the case wouldn't affect the green card process unless it had to do with abuse of a child or sexual violence of some kind. Okay. Um, so as far as the case is concerned, if he's the US citizen, it shouldn't really, like I said, it shouldn't affect the case that much. If he's not the US citizen and he's the person trying to get a green card, that's a problem. Okay. You may want to know what that case is because that may be the reason that the case is not moving forward. Because again, USCIS is not going to approve a green card if there's an open criminal case going on. But if, like I said, if the husband is the US citizen, you want to contact USCIS, right? You can do the 800 number, see what's going on, because that is 2021 is a long time for there not to be an interview or a request for evidence or something. So it's most likely outside of normal processing time, and you will only know that by calling USCIS and getting a service request done. Okay. But sometimes things do get stuck, but you want to know the full picture um, of the situation first. Okay, if husband is okay, then you need to call USCIS and see what's going on there. And hopefully he will eventually tell you what the case is about. If Okay, so what I will want you to look up is Adam Walsh Act, because that's something that will also affect your case if that's the basis of um, the court case. Okay, just think about that. If I found out that my spouse is using me only to get a green card, what should I do? Um, if they're using you for a green card, have you filed the green card process? It's up to you on what you want to do. You can stop the process. You can withdraw your application. You can end the relationship. That's really what you can do, right? Is end the relationship. And if you've started the I-130 process and the I-130 process, but you want to be sure that they're using you for a green card, because I've had situations where people come to me after withdrawing and want to start the process over again. And we have to explain to USCIS why they withdrew in the first place. So that would be my answer to your question. Mary's asking, so there's no other way to get the green card sooner? 15 years is a lot. Yes. Okay. So the 15 years, I'm sorry to add on to the years, but the 15 years is to get the U visa. Okay, the 15 years is to get the U visa. You have to have the U visa for 3 years before you can apply for a green card. So the 15 years to get for a visa to be available is only to get the U visa. It is not to get a green card. You still have to wait 3 years after that to actually get the green card. All right. Sorry. I know. Not great news today. Not great news today, Mary. But I'm glad you're joining me live and you get to ask me your questions. So I'm glad about that. And so another question. RFE came in, but it was only related to his case and nothing else. He answered and sent that 6 months ago, but it's back to case being reviewed. Also, thanks a lot for your responses. Oh, okay. Yep. So if the RFE is about his case, it's most likely around the Adam Walsh Act. So it takes time. Those cases take a long time because USCIS has to basically make certain determinations before they can move forward with approving your green card, right? Because it's the I-130 that's on hold. It's not even your green card application. If they are able to approve the I-130, I'm sure your green card process will probably be fine. But that Adam Walsh problem is what usually holds up the I-130 process. So if they send an RFE for his case specifically, that's probably what it is, and you just have to wait. And do not look at the case being reviewed as anything other than USCIS putting a status on it. It does not mean that it's currently in front of an officer for 6 months, right? That's not what that means. It just means that that's the status they put on it. Some cases can have, case being reviewed as the status for like a year. That can be the status for a year. It does not mean that your particular, case is actually truly in front of an officer. So the only way to really get, to do a service request would be your best bet. But if you're working with a lawyer, especially with that Adam Walsh issue, you want to follow up on that. Okay. Can I drop the application anytime? Do I need any proof that he is using me for a green card? So if you want to withdraw an application, you just have to send a written notice to USCIS asking to withdraw your application. You do not need to put a reason why you want to withdraw the application. Okay. Withdrawal can just be as simple as I no longer want to move forward with the application. So I'm asking to withdraw my case. Right. So I typically do not recommend including details because, again, I'm trying to think of the best way to put this. Sometimes our view of things may not be reality, and we don't want to put things out there that may not be 100% accurate or just from our feelings. So just make sure that you can withdraw at any time before it's approved. Once it's approved, you can't withdraw it. Okay. So that's what that's what I would say on that. You can withdraw it up until the time that it's approved. Once it's approved, there's no withdrawal. Okay. And your withdrawal can just be, I wish to withdraw the application. I no longer wish to move forward. 2 sentences. That's it. All right. God's favorite. Yes. Please feel free to send, you can go on my website, lilylegal.com, and schedule a consultation right on there. Pick a date and time that works best for you. And we can see what we can work out. What is the average time for I-130 approval right now? Typically, I-130s that are filed, if it's filed with a green card application, it may be a little faster, but an I-130 for the spouse of a U.S. citizen, it's around a year to a year and a half. All right. Mary, that is great attitude to have. So Mary's saying, thank you. I have waited 6 years for it being the U visa. 3 years is nothing. Yes. 3 years is nothing because guess what? After that, you get your green card, you wait another 5 years, you get your citizenship, and you are done with the immigration process. So yes, that is the right attitude to have with US immigration because things take way longer than we want it to take, but there are things happening in your case. So just hold on to that, right? You can get your work permit, you can do things here, you can, you just have to wait. So great attitude to have. Really like that. If you have any other questions, please put them in the comments. I am happy to respond to those. If I don't see any, then I will assume that I have answered all your questions for today. Just playing. Feel free to put your questions in the comments if you're watching this on the replay. If you're joining me, and you can hit the like button to tell me that you're enjoying this video and I am giving you some good information. All right, so I do not see any other questions. So thank you all so much for joining me. For those that don't know, I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. If you want a consultation with me where we look at your situation and figure out what the best options are for you, you can do that one of 2 ways. You can go to my website, lilylegal.com, or you can call my office at 508-443-1788. All my contact information will be in the description to this video on YouTube, Facebook. Instagram has its own brain, but if you go to my page on Instagram, you can see all my contact information as well. So the phone number is 508-443-1788, and the website is lilylegal.com. www.advertisement.com. Thank you all so much. And hi, Don. Welcome. I hope you have um, a great rest of your Friday. And God's favored, we offer a free 15-minute strategy session just to see if we need to do a deeper, longer consultation. The longer consultations are 200, but that initial 15-minute just to see where we are at and if we need that longer consultation is completely free. So feel free to do that. Okay. All right. Well, have a great rest of your Friday. Have a good weekend. And I will be seeing y'all next time. Bye.